I found an excellent video that will help us better understand, hopefully. So let's go ahead and get in. Let's make this happen. Let's go.
So I think you're going to see a much more efficient trial being run by this judge. I think what you're going to see here is a little tighter ship. You know, she wants to get this trial done. 6 months. 6 months. There's just no rhyme or reason that this case should have taken this long. And we're getting some of our information from Thugger Daily, and so shout out to Thugger Daily because he's following this like tooth and nail and doing an excellent job. And she's on the stand, right? So we're taking a break and we're in chambers. She's going to say this, this, and this, and I'm like, where the hell did that come from? And I said, that's fine. I've got other witnesses that are going to piss all over her anyway. And you know, and I just said that. I just blurted it out. And the judge looked at me and said, excuse me? And I'm like, shit, what did I just say? This was a long time ago. I was much younger and I was much less mature than I am now. There's a new sheriff in town, and her name is Judge Whittaker. Court will begin at 8:45, no matter what, regardless of whether the defendants have any of their lawyers present. No more eating in court unless the day goes on longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants. Sorry, Thug. Asking to minimize disruptions in the court. Defendants cannot be using headphones during the trial, and no gaps between witnesses. State needs to have their next witness available immediately. So what you're going to get from this judge is a more tightly run ship. A lot of things going on in this case that are just don't happen in normal cases. You don't have 3 judges. They're on their 3rd judge now. Today we're reacting to the news that there's a new judge, a new sheriff in town, on the YSL trial, and she's not taking shit off of nobody. And so Brian's, okay, let's just back up a little bit. So Judge Glanville, who has been handling this case for way too long, a lot of things going on in this case that are just don't happen in normal cases. You don't have 3 judges. They're on their 3rd judge now. So Judge Glanville had a motion to recuse himself from the case back in June. That was denied. The Court of Appeals have come back and granted that motion. I don't know if it's Court of Appeals or another judge, but that motion has now been granted. The order on that recusal motion is not saying that Judge Glanville couldn't be fair or whatever. It was basically saying there's might be an appearance of impropriety at this point. And that's why it wasn't basically on the substance, it was basically on the appearance of some impropriety. And Steele and Glanville, if you remember those video clips of the two of them kind of going at it, I mean, it was just harsh. And he tried to put him in jail. And he was vindictive when he said, where did you get that information from?
Names must be named.
What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to... No.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information...
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
And so then Judge Ingram was assigned to the case, and then she recused herself. But I think there was some initial motions that she ruled on early on regarding Steele. I think there was a motion to get Steele off the case because he had represented so many people, and the government said he's a critical witness, which they haven't called him, and he's not a critical witness in this case. So now we have Judge Whittaker. But all right, so let's just take a look at the new rules. The new rules. There's a new sheriff in town, and her name is Judge Whittaker. Court will begin at 8:45, no matter what time.
Okay, so we need to start. We need to revisit these because I think it's fair to say that just about every one of these has been violated. I mean, she started out strong, but I think every last one of these have been violated. Let's let it finish. But yeah, this is wild.
If all the defense, regardless of whether the defendants have any of their lawyers present. No more eating in court unless the day goes on longer than expected and they have to work through lunch or dinner. No more extensive wardrobes for the defendants. Sorry, Thug. asking to minimize disruptions in the court. Defendants cannot be using headphones during the trial, and no gaps between witnesses. State needs to have their next witness available immediately. So what you're going to get from this judge is a more tightly run ship, okay? And there's just no way that this should be taking as long as it is. If this was federal court, this would have been over a long time ago. You know, they took, 8 months to do jury selection? That's insane. That's absolutely insane. There's just it should have maybe taken a week to 3 weeks at best. And if it was in federal court, it would have been done in less than a week. So let's take a look and see what the tenor is going to be in court with Judge Whitaker.
So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot.
Tempers have flared, but not just from the defense, from the Judge Glanville, and the prosecutor. You know, and it's not uncommon. In every case that I handle, I try to be professional. But once in a while, somebody gets under your skin or whatever, and tempers fly. But, you know, you get in the heat of the battle, and you see how animated that Steele has gotten. You see how animated the judge has gotten. They've all gotten unprofessional.
And that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather. And everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that. Okay. But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk. Okay.
Keep telling yourself that, darling.
That's excellent. What a great tone to set. You know, as you say.
She set a tone, Bruce. She did. You're right. The problem is that tone died down pretty quick. She started out with the smoke, but it was no fire.
She started out as the new judge in this case. And we're getting some of our information from Thugger Daily. And shout out to Thugger Daily, because he's following this like tooth and nail and doing an excellent job. But let's hear, from the status conference, the motion with Brian Steele.
So I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it, taken away and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
So what he's basically saying is that he filed a motion to recuse Judge Glanville. Mm-hmm. He denied that motion. They took testimony after that motion was filed from Copeland, Lil Woody, and then they
shouldn't have done that.
The motion was later granted.
Yep.
And it wasn't granted on substance, I don't think. It was really more granted on an appearance of impropriety rather than actual, bias. But so the theory from the defense is that anything that happened after Judge Glanville's the motion to recuse Judge Glanville happened, that you got to get rid of all of it. And there's case law that says that. So if you listen to the tone of Judge Whitaker, she's new to the case, says she hasn't been following the case. The jury's on a break now for 2 weeks until August 5th. And let's just get a little more flavor of what her attitude is.
All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Yeah, there's no way. The rulings have been made, and there's no way you go back and you're not going to redo this whole trial. That's not appropriate.
Once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well.
I think what you're going to see here is a little tighter ship. You know, she wants to get this trial done. 6 months. 6 months. There's just no rhyme or reason that this case should have taken this long.
But the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary?
They're still doing it now, though. They're still doing it now.
And if nobody wants to, then we'll just do away with it.
See, and she's to the point. She's direct.
I think it was originally combat order.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And whether they're going to present a case or not. A realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly, because this case has been going on for a really long time.
She's mindful of the fact that it's ridiculously managed and it should be over by now.
And there is a rule that lets me exclude cumulative evidence, and I might end up using that. So how about y'all give me a heads up on all of that, okay?
So if the prosecutor brings in a witness that somebody else has already testified about those facts, maybe one, to reemphasize the point, but not over and over and over and over again. So they're going to be back on Tuesday at 8:45 sharp, without headphones, without a fancy wardrobe, and you're either there at 8:45 and we start, or you're not at 8:45 and we start. So this judge is basically laying down the law and trying to be as kind, and you can hear her tone. Her tone is very congenial, right? But what she's saying is not congenial. What she's saying is, we're going to run a tighter ship, we're going to get this trial done, and we're going to get it done in a lot short order than we had before. And she's not going to put up with the state, I'm running out of witnesses today. No. That ain't going to happen. Boom, boom, boom,
Okay.
boom, boom. So I think you're going to see a much more efficient trial being run by this judge. And quite honestly, that's what the jury needs. I mean, there's no way this case should have gone on this long. 10 months for jury selection? That's insane. That is absolutely insane. If it really would take that long, then you should break it up. Here's one of the other problems that you have. It's 6 months now, right, of testimony. Jurors forget shit. And the message that's being imparted, what are you going to have, like a 3-day closing argument?
Sorry about that.
And your message is going to get lost. You need to be boom, boom, boom. You make your point, get out. And I think this prosecutor is doing the courtroom a disservice. And Judge Glanville has allowed it to go on for so long. And I'm glad he's off this case. He proved himself to be very ineffective. And we're going to see a much more streamlined trial presentation from here on out. You watch. And you're not going to see her, meaning Judge Whitaker, take a whole lot of shit from Brian Steele or from Miss Love. You're not gonna see it. But we got
Okay, I might have to clip this. I just met Bruce. I'm just met Bruce. So Bruce and me are not, we're not friends yet. I might have to clip this and send it to him because boy, oh boy, is he going to have to eat those words. Get him a big old bowl, a giant spoon and some Wheaties. You're going to have to eat those words, my guy. She is totally taking all of the mess from Love. Oh my gosh. Okay, let's go. This is almost done.
a whole bunch of motions flying this way and flying that way. And guess what? She's going to rule from the bench, and she's going to rule like that. She's going to rule fairly quickly. The judge is going to hear all kinds of motions. You got a motion to exclude Copeland's testimony. You got motions by the prosecutors. I don't know what the hell their motions are, but they're filing motions back and forth. And then you got a motion to recuse Love because she's a critical witness in this case, which, if you recall early on, they did the same thing to Steele. And that's not going to go anywhere. And that's based upon Miss Love texting a witness, and it is what it is. So we'll see what happens. I don't think they're going to get disqualified. I would caution Steele against filing motions that are frivolous because I don't think this judge is going to take too kindly to it. And she's going to be boom. I think that's what you're going to see. You're going to see her being a little more curt than right now. She's kind of in the honeymoon phase and just trying to lay down the ground rules in a very nice and and polite fashion. I don't think you're going to see that moving forward. I don't think she's going to be rude, but I think she's going to be decisive, and I think she's going to be curt with people who are wasting the court's time. And that's what's been going on. The court's wasted the court's time up till now. We're going to keep we'll keep on this. Shout out to Thugger Daily because
Always
you can
Thugger
get a lot of
Daily.
good
Always Thugger
information.
Daily.
It's where we get some of our information. I just put a legal spin on stuff that he's presented, and you just watch. This is going to be a much more streamlined trial. So we'll see you next time here at Criminal Lawyer Reacts. I'm Bruce Rivers, your board-certified criminal defense lawyer. You know who you are. And we'll see you next time here on Criminal Lawyer Reacts. Make sure you subscribe. Follow us on Instagram. Follow us on Twitter.
I thought this was a good one
Sign
to
up for
kind of
Patreon.
remember when we all thought that Judge Whitaker was going to be the bee's knees. We said, oh my goodness. Oh, this wit. Oh, that last name. We were all hoodwinked. We were all bamboozled. We were all run amok. Everything was so great. Everything was wonderful. And now, just like Zipper Jones says here, she taking all the mess and looking for scraps. She is totally flipped out on us. Now, I will say this, though. There's been a little bit more, I think it's not decisiveness. I think it's upsetness. Whereas before we said, oh, she's going to be right down the middle, balls and strikes. Now she's like irritated and she's upset. So when she says stuff now, it comes across like you're PO'd, like you're upset at me rather than you're calling the right thing. And it's mainly because she's allowed, and again, she's been taking all the mess and looking for the scraps. That's her fault. So I just thought this was really fun. A reminder from somebody who's totally outside of it. So he was hoodwinked too. I would love to hear what he thinks today, because this was almost a month, maybe a month and a half ago. I would love to hear, like, what is Bruce saying today on September 12th? What is he saying now? Because I bet you he's probably changed some of the things. For nothing else. They're eating in court. They got headphones on in court. I don't know about the wardrobe, but my goodness, in the morning. If Judge Whitaker had not culled the herd, so to speak, nothing would have been done as it relates to.
Yo, hit that like for deal with Christian. Yo, for deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian. For deal with Christian. Smash that bell for DWC. Yo, smash it. Just smash it. Hit that like for deal with Christian.